Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a treat for you today. Last week, we spoke about the Herculean efforts of Lori Hellis to basically make the record available to the public in the Lori Vallow and Chad Daybell matters. And she has been kind enough to join us today to talk about what she's doing and hopefully where we're headed. Lori, thanks for joining us.
My pleasure. Thanks for having me.
So when we talked about you last week on our show, it was very evident that you have a big following and people love you. So why don't you give us a quick bio of your background and kind of where you started and how you got to where you are right now?
Sure. I'm a retired criminal defense attorney. I practiced in Oregon for all of my career. I'm licensed in both Oregon and Arizona. I'm now inactive and retired. I'm retired to write. Discovered the Lori Vallow and Chad Daybell story when I was living in Arizona, in the urban Phoenix area, so near where Charles Vallow was murdered. And Justin Lum from Fox 10 was doing a lot of coverage about the murder. And it just caught my attention. So strange, missing children, odd belief system, all of those things sort of caught my interest. And the more I, of course, followed the story, the more interesting it was. The week that the children's bodies were discovered in Chad Daybell's backyard, I went live with a newsletter because I found there were a lot of people that had a lot of, as you find, a lot of people who had a lot of questions about legal stuff and a lot of kind of legal misinformation. So I thought I would start a newsletter just talking about the legal issues in the case. And that has sort of grown into my agent and I pitched the book idea, and Pegasus Books is going to publish the book when it comes out. And in the meantime, I'm have moved to Boise, Idaho to be close to the case. And in the meantime, I'm doing lots of research and waiting for the trials to start in January.
Well, that's great. And obviously, I know there's lots of people in the true crime arena, but as a retired attorney to an active attorney, not that we know everything, we don't, because there's lots of good tips, but I think that we can provide a little bit of a nuance that a lot of people just don't get. If they're not familiar with the legal process. And I'm not talking, oh, they're a lawyer. I'm talking actually practiced as a prosecutor or as a defense attorney. There's just those little nuances of things you expect and the things that you anticipate to see that hopefully we can tip our viewers off to that say, oh, maybe they do know what they're talking about.
Right.
So obviously, like you said, this is an interesting story, the Lori Vallow, Chad Daybell. I mean, you've got missing children, doomsday cults, and I use that in air quote because some people get offended by that or what have you. But in my experiences, having represented people on a case where people died with doomsdayers, anytime there's a doomsday plot, there's usually going to be problems. It's usually going to involve law enforcement at some point. So you got that intrigue. Then you have Tammy Daybell, mysteriously dying, Chad and Lori getting married, like 7 days, 14 days after her death. It's like, this just isn't right. And then you got just the weird stuff with the brother dying and her prior husband passing away unexpectedly, unexplained. I mean, it's like, as they say in politics, there are no coincidences. I mean, in a homicide case, like there are no coincidences, right? No. And that's kind of where we are. I don't think that's the thing that's intriguing to me, but obviously it must be intriguing to you as well.
Oh, very much so. Very much so. And I think as the case has gone along and we have seen how it's progressed through the court, that piece has sort of frustrated me in terms of the number of sealed documents, which is how I got involved in filing these motions.
All right. So let's talk about that. You have filed your motion to basically tell the court, hey, you're not following the correct law. You
Right.
can't just seal these on a whim, these documents, these hearings. What made you decide to do that? Was it just frustration, or obviously for your own interest and everybody else's to make sure we get this open?
For my own interest, but of course, Scott, criminal defense attorneys are notoriously passionate about the Constitution, and the more this case went on, and the more Judge Boyce sealed documents, the more frustrated I got with it.
Yep.
Every time he'd seal a document, I'd think, that doesn't sound right. That's not right.
Yeah.
So finally, I got frustrated enough to sit down with the Idaho statutes and figure out under what circumstances a court actually can seal documents, and discovered very quickly that Judge Boyce has not been following the statute and the protocol for sealing documents. So it's clear, it didn't sound right to me, because I knew that in the states where I've practiced, there's definitely a more prescribed process for sealing documents. And it seemed odd to me that the prosecutor could file a motion and the judge could sign an order, and there was never any discussion about it.
Yeah.
So it turns out that the statute does require that the court hold a hearing after notifying all of the parties and any interested parties, any other interested parties to the case. So if you look at just the court database, you can see that there's motion, order, never a hearing having to do with them. So they're clearly not following it. And I think it's a little bit of, it's a very small jurisdiction. And I think that it was a certain amount of inexperience on Judge Boyce's part. He just was appointed to the district court before COVID hit.
Yeah,
so he hasn't had
before, I think.
Right. So I think it was a bit of an inexperience on his part. And then I think it also was a little bit of the good old boy kind of thing.
Yeah, it was convenient for everybody, I think, is what it came down to. So I remember, before the electronic age, when you filed something, you had to go to court. You got your date stamped copy for your file to show that you got it stamped in time. And you could go down and pull any file. You went to the records room, you filled out the little piece of paper, who you are, what are you going to do with the file, and you could copy, you could look at anything. The judges took their notes out if there were, documents that were previously identified as privileged or sealed. The clerk would keep those back. But you could go and look at every filing in every order. And then the electronic age came about. And I know you haven't practiced law in Colorado, but here in Colorado, there was an issue where the press looked at it and said, why are we suppressing all of these cases from the public information when, once again, they're not following the procedures, and the courts were just kind of doing it for convenience? Like, well, they seem really nice and this could be embarrassing. But that's what happens when you go to a public proceeding. You're getting all your laundry aired out there, and it may be embarrassing. And so the fact that you took the time, and I think, and I may note, very well written motion and brief in support thereof, outlines the facts. I even said, when I was talking about, I was like, she outlines the facts, then the law, the issue. This is like good legal writing. This is great. So kudos to you.
Thanks.
So I agree with you, and I've complained about it, but unlike you, I did nothing about it. I just complained about it. You said, let me go do something about it. So I think that's absolutely great that you did that. Has anyone acknowledged these yet? Has the court notified you? Are you on any mailings at this point, or, certificates, notifications?
At this point, I have not received anything. I spoke with the clerk of the court. Now, you have to envision Fremont County. I practiced in a couple of these jurisdictions, so you have to envision this is a little historic courthouse with 2 floors. Literally, the court records and the county people who give marriage licenses, they're all in this same little old courthouse. The prosecutor, Lindsay Blake, who I think is a one-person shop, is directly across the street in a little brick building. It's just, it's very much small town law practice. In fact, Judge Boyce practices in that county as well as Madison County, where Rexburg is, and goes back and forth between the two. So it's a really small town.
Yeah. When we went to Madison, Frank and I went over there one day,
Right.
jumped in a plane and went over to check it out. And yeah, it's small town, and I know exactly what
Right.
you're talking about.
Right.
But wouldn't it be nice to live in a town where you only had one prosecutor? Because
Yeah.
instead of staff of hundreds of attorneys,
Right. Right.
It says something about the area. It's pretty low crime.
It is, and it's a beautiful farm area, and it's a lovely community.
Absolutely.
But they're also, because it is so low crime, they're also really not equipped to deal with this huge case. And this case has gotten interest from all over the world, not just national interest, but international interest.
Yeah.
I'm sure you see it. We see it at Hidden True Crime, where we have people from all over the world who tune into our live broadcasts. We get people who set their alarms to get up in the middle of the night and catch us live from South Africa. So, there's a huge amount of interest in the case. And I do understand that the defendants are entitled to have their day in court and to have an unbiased jury of their peers. But that doesn't entitle the court to seal every document. And I think where I finally got to the point where I thought, this just can't be right, is when the judge sealed all of the documents requesting that the two of the prosecutors be removed from the case.
Yeah, that was problematic to me as well, because that's significant, right? These are elected officials. We have a special prosecutor. We have somebody who's been admitted pro hoc vice to come in and assist with this case, and they're saying they need to be off the case. Why does the public not have a right to know what is going on? I mean, it is a public courthouse, a public trial, public documents. And I get it. If there's, the competency evaluation, we're not going to get that. I get that, privacy issues, but everything else is fair game and we're entitled to it. And the only thing that matters in a court of law, it doesn't matter what was said outside of it. It only matters what legal and competent evidence is admitted into evidence via witnesses and, obviously legally permitted evidence in the case. So no matter what was said, it depends on what's submitted in court. So I think this whole preserve a fair trial for everybody is not well placed.
Well, my opinion was that certainly the defendants are entitled to a fair trial, and they're entitled to have jurors who have not formed an opinion about the case. But they're not entitled to a pristine jury pool. If that were even possible, they're not entitled to it. No. And I was troubled by the fact that we have a defense attorney who is asking to remove a prosecutor, two special prosecutors, one of them elected in the neighboring county, and all of that is sealed. To me, that smacks of, we want to look out for one another because nobody wants to be embarrassed.
Exactly. And I was thinking about this weekend when you filed the motions, because I was like, I got really excited about it. I'm like, this is great. And I thought to myself, why didn't I do that? Jeez. But like I said, seriously, we refer to you as a hero. And I mean that because, we've talked about it. It's like, it's just not right. People shouldn't be doing this, but you actually did something about it. So kudos to you. But I agree that was the problem. It's like, should we be worried? Like, the fix is in, we're going to go through this. We're going to, kind of play around for a little bit, but then we're going to come to a deal. Don't worry about it. Everything's going to be okay. And, I think, God, this is a death penalty case. And I've only done one death penalty case as a defense attorney, start out as one. But I mean, you were thinking and filing motions and on everything because you get hyper due process. and there's
That's right.
almost no activity going on here, which
Mhm.
makes me go, hmm.
Yeah.
So yeah, I understand your fears, but it makes me concerned that, like, is the fix in? Like, just kind of go along with it. We'll do it because I really feel, and although I like Mr. Wood, and Ms. Blake seems, they all seem very competent, all the prosecutors on the case. But I also think that it's a small town, and I'm
Right.
not saying they're not good attorneys for being in a small town, but they just don't deal with the issues. And my
That's right.
concern is that they're getting overwhelmed with all this electronic discovery where they're talking,
Mhm.
if they had to print it out, millions of pages and all that, space on a hard drive, and that they can't, it's their case to lose basically. If they don't do it right, they could screw it up. But we have a right to know if they're screwing it up. Hell, we'll point it out to them. We'll help them.
Well, I do think that particularly in that case, we have in that particular set of motions, we have John Pryor asking for permission to file an interlocutory appeal. He
Yeah.
feels there is something seriously wrong, that it justifies removing the prosecutor. And if that's the case, then I think the public, and more importantly, I have a a very nice relationship with several members of the victims' families. And I feel a little bit of an obligation to point out when they're not getting the information that they need as well. And I've heard from them, what the heck? We think Rob Wood is great and he's been our champion throughout all this, and all of a sudden they want to remove him. You know,
What's going on?
what's
And
going on?
well, exactly. And if John Pryor has a legitimate claim, right, that can go forward and say, hey, these prosecutors should be kicked off. And like you said, he wants to file an interlocutory appeal to the Supreme Court.
Right.
As an officer of the court, you have to have a good faith basis for that. You're not just going to file frivolous motions just because. You have to have a good faith basis, particularly to your Supreme Court, that could affect your licensing, right?
Right. That's right.
But if it is frivolous, I'm sure the court of public opinion will also let him know if it's frivolous or if there's a good faith basis for it. And I just don't understand. So I'm glad you did. I just don't understand, like you said, why they're stealing stuff. And obviously now they're not following the correct procedure. And I think you politely and eloquently told the judge, hey, judge, you seem like a good guy, but you're not following the rules. So I'd be curious to see if he changes any procedure here shortly.
Well, it will be interesting. Along with my motions, I did file a motion for an injunction that the court can no longer seal documents without following the law, which I suppose you shouldn't have to file an injunction for that, but just to sort of be double extra cautious, I did. So I'm hoping, what we know is that there is a hearing coming up on August 16th. That hearing was actually previously scheduled prior to my motions being filed. And it is a hearing to talk about the consumptive DNA testing, as well as John Pryor's motion to remand the case back to the jury, or to the grand jury. Yeah. That's a whole interesting conundrum. I worked as a prosecutor at one point. Yeah. And, prosecution 101 is you never put two crimes in one charge.
I know. I thought it was interesting, Mr. Archibald's motion to remand. I think Pryor filed something similar, but yeah, I mean, now they got to go. I mean, my first reading is like, I haven't seen the response yet, but it seems like somebody needs to go back and supersede, which means if that grand jury is not in place, they got to go and panel a new grand jury, present all the evidence all over again, which means more transcripts, potentially more delay. And, Mr. Archibald, he's had very little involvement in this case thus far, but he seems to be very competent. Along with Mr. Thomas guy, who I don't know, hasn't really said much, but from what I can tell, they're death penalty qualified there in the state of Idaho. So they know their way around a courtroom. And they're saying, hey, you can't do this. Go back and remand it, which the DAs have got us said, oh, gee, I think he may be right here.
Yeah.
So, like I said, it's their case to lose.
Right. So a lot of folks have asked whether or not that hearing on the 16th is going to deal with these motions. It's not. I've had a conversation with the clerk of the court, and the motions hadn't been set. In fact, she was waiting to hear from Judge Boyce when he is back in Fremont County tomorrow to discuss when to set the hearings.
Well, I hope he does it expeditiously or on the same date. It seems like something that could be set, and Judge Boyce has a tendency to set a date to set a hearing date. I mean, have you noticed that? I mean, as a, former prosecutor, defense attorney, like, God, we have a lot of dates to set dates here.
And I've worked in jurisdictions where that's the case, where we set dates to set dates. Yeah.
And because I travel all over our state, and we get very rural once you get out of the Denver metropolitan area. Yeah. And my experience is the farther you get away from the main city, so to speak, they're more inclined to set it out. Can't we resolve this? Why do we want to inconvenience everybody with a big old jury trial for? Can't we come to some resolution? Let's set another pretrial conference date. Right. So we'll see. And I mean, I think Judge Boyce is trying to do the good job. But, like I said, a guy that he's been a magistrate for a while. And then next thing you know, he's got one of the biggest homicide cases that's being followed by people around the world. And you got to make sure you're dotting all your I's and crossing your T's. And like I said, it's a matter of convenience. That's the way we've always done it around here. Let's just go ahead and seal that up. And somebody called him on it. So good for you.
Thank you. Thanks.
How long are you going to wait if the judge doesn't respond to, file a notice to set or something?
Oh, a couple of weeks. I'll give him a couple of weeks to set the trial date, to set a hearing date. And I intend to be there and argue my motion. Well,
I mean, you're certainly qualified and a very good writer. I must say so myself. Your briefs were great and laid it all out and said, Judge, respectfully, you're not doing a very good job on this subject.
What you're doing is kind of illegal. Yeah.
Yeah. There's no real, I mean, I guess his only remedy is to unseal everything and then, or unseal it, hold a hearing to decide if they should seal it. But I just don't think they can. I mean, it just goes it flies in the face of our system of justice, that it is a public court system where the public can go in and should be able to pull the file and say, I want to see what's going on in this case.
Absolutely. Absolutely. Yeah, I think in some ways, electronic records have caused some problems for us. In other ways, they've made in the systems where every document is scanned into the database and is available as a clickable PDF link. I think it's made it much easier. But Idaho doesn't operate that way. You don't get a link to click to the document unless it's listed in that list the Supreme Court puts out of all of the Idaho court cases of interest.
Yeah, the Idaho court cases of interest, which I might also note usually is a significant lag from when anything is filed until it makes it on that list. Usually 3 to 5 days is my experience.
Right. That was about how long it took for my motions to hit that list.
Which in and of itself is frustrating in an electronic digital age. Yeah. You know how it is. If we file something, boom, it goes to everybody. They can tell who opened it, who read it, what they're doing, printing it out, all that kind of good stuff. So they say that, oh, look, there's notice. So anyway, we're getting too far in the weeds there. But we did a story today. There was a judge in South Carolina on another case that we've been following, the Murdaugh case. But the defense attorneys in that case said, Judge, let's put a gag order on that. We're going to file a motion to basically seal. We're going to do all the motions hearings in private. And the judge said, not in my courtroom, because this is a public courtroom. And I'm not going to keep the public from knowing, no matter how embarrassing it may be or become. So Judge Boyce will figure out the errors of his ways through your motions.
Yeah. You talk about small town practice. The Murdaugh case in South Carolina is incredible. One of the things that was interesting about that case was that the prosecution and the defense agreed to that gag order before they went to court on his bond hearing. So
Yep.
that was fascinating for the judge to say, don't think so, boys.
Yeah. And, the funny thing is when the judge denied that, the prosecutor in the Murdaugh case said, well, we can't talk about that anyway. And that's not the gist of it. Obviously, they're not supposed to go out and make extrajudicial statements, any prosecutor or defense attorney, that could influence the case, right? Other than saying my client's not guilty and we believe the evidence will show that the defendant is guilty, right? That kind of stuff. But they wanted to do everything in private, which goes back to that good old boy network that they don't need to know our dirty business over here. And thank goodness the judge said, no, we're not going to allow that. Because it just frustrates me that we even have to wait 3 to 5 days on motions that are filed directly. Where when I was, when things weren't so electronic here in Colorado, things got filed, and it was not uncommon for the news media, the Denver Post, to say, hey, we want to record the proceedings. We want to do whatever. And if the court denied it, the Denver Post here, they had their attorneys and they were going off the court to litigate it. Are you a little surprised that we haven't seen any of that by local media out there?
I'm quite surprised. I was quite surprised that we haven't seen it from Fox 10 in Phoenix. I'm not so surprised that we didn't see it from East Idaho News and the folks that are much closer to the story. For the reason we talked about, when you're a local news reporter, you really need to protect your connections with the local people in local government, because you know that you're going to be going back to them time and time again. So I suppose I'm not really surprised that East Idaho News, Nate Eaton, hasn't gone directly to it or hasn't had their lawyers file something. But I was a little more surprised to see that the folks in Phoenix hadn't done it, because they don't have quite as much connection to the case in terms of protecting their sources.
Yeah. And I think Nate's done a very good job, and he, he's got a couple of good scoops, so to speak, clearly through sources.
No
and I
doubt.
understand where you potentially wouldn't want to, upset somebody. But, at that point, the station or the newspaper is saying, it's not him. You keep talking to him, sources, but we're doing it for the community.
Right.
Because my experience was, the newspapers and the news channels, they had these First Amendment lawyers on contract to go fight the good fight to make it protect the First Amendment, so to speak. So, well, I want to thank you for coming on. This has been great. You have an invite to come back anytime you would like.
Thank you.
And we can talk about this case or any other case that you desire.
That's great.
And
I'm focusing on this one right now.
Well, I look forward to your motions to be ruled upon, because I think you are correct. And I'm also assuming nobody's filed an objection to your motion, correct?
Not that I know of.
It would take 3 to 5 days to get notice of it, right?
But certainly I would need to be served with them. I haven't been served with anything yet. So.
Okay. Well, that's the job of, I've always said it, the job of a good defense attorney, or in this case, you, a member of the press now, right? To be able to have access to this is to basically say, hey, you can't do this. I'm telling you, judge and prosecutor, you can't do this. Although you may hate me, I'm doing it anyway, because you can't do this. You got to follow your own rules. So I've said it once. I'll say it again. I will continue to say this. Lori Hellis, hero. Hero.
Thanks. Maybe we can talk again when they rule on the motions.
Oh, absolutely. I will be following. I will let the world know, because I think you're right and you should win. And if you don't, we all got to be worried, because the fix will be in, so to speak.
Great. Well, thank you.
Thanks for joining us, Lori.
Thanks for having me.